P. In each of these matters, Mr. Jackson is here today after failing to appear before referee Courteau on January 6, 2022. Bond in each case is currently set at $500. This is the fourth bench warrant in the first case and the first bench warrant in the second case. He reports no employment. Last payment made on these accounts was on July 1st of 2023. Front of the court recommends that reasonable bonds be set in each of these matters and they be scheduled for hearing on July 19th, 2023 at 8:45 a.m. before this court.
Thank you. Mr. Jackson, you're before the court charged of civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on July 19, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Honestly, I don't know right now.
No, okay.
I'll have to make some phone calls.
Okay.
I'm not sure it does guarantee that I can post a bond.
Okay.
But is it all right if I run something by you, sir?
Well, most of the time, what we're looking at is just a bond issue. Anything with the case would be decided on the 19th.
Yeah, I just want to say that on the January the 6th, I just moved back to the state of Michigan in March, so I was not aware that I had court. And then I have been working for the past 2 years, and they took the tax money. Like I owe them for child support like $1,100, but right now at the FOC they have a check for $953 that they already had got from my federal taxes that they cannot release into their account. So I had to go to H&R Block and file an 8821 form like a week and a half ago for them in order to like do some paperwork and release that check to the FOC. But the FOC already has that check. And I do have like a job opening because I already did a walkthrough, but they told me to come after the 4th of July because of the 4th of July weekend. They said after that, then they would place me out at the job, ASMO or Asama in Coldwater. I was working at Clemens and I just stopped working there like 2 weeks ago, and I was going to get another employment. So
okay,
I don't know. All right, I guess
Mr.
I'll be here till the next.
Mr. Chapman, prior to the first, had there been regular payments?
There was income withholding in effect between June 5th of 2023 and July 1st. So there was income withholding for about a month.
But I honestly did not know.
Prior to that, the last payment was in July of 2020.
Okay.
Yeah, I had lived in Arizona and Texas for 2 years. I just moved back to Michigan in March. And this $1,100 that I owe to child support is from, if I'm not mistaken, from 2018 when they legally took my son until the age of 18. They took him, so they said that I can't have contact with him until he's the age of 18. And so it's like back pay that I owe to the foster care system that I wasn't even aware that I had to pay because I thought once they took him until he's 18 that I would no longer have to pay child support. But I don't know where these back pays came up, and I've been gone in Arizona and Texas for 2 years. I just moved back to Michigan in March, and like they got $953 of holding already, and I only owe $1,100. This is my first time that I ever owe child support ever.
Okay. Is that approximately the arrearage, Mr. Chapman, 1,100?
I have no way of looking off of this computer.
Okay.
I apologize.
That's fine. What I'm going to do, Mr. Jackson, and based upon your statements, I'm going to set your bond in each case in the amount of $100. If you're able to post that, you'd be able to be released. Do you have any questions?
Mr. Warren, no, sir. Today, after failing to appear before this court on September 28th, 2022. For the record, that was a bench warrant hearing. Mr. Warren was previously before the court for a bond review hearing on September 16th of 2022. He was given a $100 bond, which he posted and then failed to appear for the hearing. Bond is currently set at $500. This is the 8th bench warrant. He reports no employment. Last payment made on this account was in April of 2023. Front of the court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on July 19th, 2023 at 8:45 a.m. before this court.
Thank you. Mr. Warren, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on July 19, 2023 at 8:45 a.m. Why did you show up on the September 28th hearing?
I was I got in a bad health issue. I was hospitalized for a month and a half. I got shot and broke 6 ribs, tore my lung up, punctured my lung. They had me hooked to a machine for like 3 weeks trying to reduce the blood out of my lungs, kept filling up with blood. And I just really getting back to health, man. I apologize. I moved from where I was living at after that because I was with my fiance. So I moved there, and it's just been kind of hectic. My father just passed, my brother just passed, my sister all just passed at the beginning of this year. I just been going through just it's not been a good year for me, Your Honor. And I totally understand. I apologize. I got a job right now. I've been working for the last year and a half, so I've been paying child support every week. It's been getting took out of my check. So I know I've been paying. I apologize for not showing up. It's not that I was, trying to ditch you guys or nothing like that. I'm sorry. I apologize. Just been going through a lot,
Mr. Chapman, has it been paid through income withholding?
Up until April, the last payment in April, there was income withholding in place.
Okay.
Yep, I just lost my job like a couple months back from when my father got killed. It kind of put me in a frenzy, man. I've been seeking psychological help, and I've been trying to keep my mom above, but I totally understand. I got a job right now. I'm working. I have no reasons not to come back to court. I promise I'll be here at my next court date. I don't want any issues. So I definitely, it's not that it's a lot. I'm sorry. I apologize. Just coming as a man.
Well, what I'm going to do is I am going to reduce your bond in hopes that you'd be able to be released. I'm going to set your bond in the amount of $250. If you're able to post that, you'd be able to be released. Do you have any questions?
Yeah, my girlfriend actually have $150. She got that right now. That'd be all I can come up with for to my next paycheck within 2 weeks. So if you could do 150, I can post that today with no problem. And I definitely will. That's just all I have. And I want to give you something,
Okay. Mr. Chapman, do you have any opposition to the reduced amount?
I do not, Your Honor.
We'll change it to $150. I will tell you, Mr. Warren, if you don't show up on the 19th this time, they pick you up again. You're not getting out of jail. You understand?
I understand, Your Honor, and
okay.
I'm greatly appreciate that.
Okay. Okay, you're free to go.
All right, thank you. Have a good day.
Yeah.
Good morning to all of you. The court will note the appearance of Ms. McKenzie on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to reinstate parenting time. Ms. McKenzie.
Good morning, Your Honor. I'll start with asking the court to grant the relief requested because no answer has been filed by the defendant mother. If the court does not do that, then I have a couple of comments. Thank you.
You can proceed. I'm not going to do it without getting some input.
Thank you, Your Honor. As the motion mentions, back in 2020, the court, after an extensive hearing, did order parenting time to the plaintiff father. And due to COVID occurring and then COVID restrictions and various other pandemic-related reasons, Mr. DeWalt started his parenting time in March of 21. And there was some hiccups. Again, due to the pandemic, he was visiting at Family Children's Services. And then he has continually reached out and visited with his daughter. We have excellent reports from Family Children's Services, this Family Children's Services worker named Amy Maxon, M-A-X-O-N. And she indicates that Harmony, now 6 years old, is very comfortable with her dad and there's no reason not to go forward with with additional parenting time. Because it has been such an extensive period, my client has visited with the child 70 times. There have been probably 20 cancellations by the mother since parenting time did actually begin March 1st of 21. And because of the excellent reports from Ms. Maxon, a neutral third party, it is appropriate that we go into what I call phase, the second phase of parenting time per the 2020 order, which would be parenting time with dad for 3 months, twice a week, 9 a.m. to 5 p.m., Saturdays or Wednesdays, unless the parties agree else on another day, as the court order of 2020 provides. And then let's have Calhoun County standard parenting time begin after the 3-month period. In addition, Your Honor, Harmony's birthday, little girl's birthday, is coming up July 27th. There was a visit planned for 2022, July 27th, and Ms. Perkins saw fit to cancel that. So we'd also like to have Harmony's birthday this year, July 27th, 2023. In addition, we're asking for attorney fees and costs of $570 and further relief the court deems equitable.
Okay, thank you. Ms. Perkins, what's your response?
Yes, Your Honor. The only few things that I wanted to bring up was on June 26th, Mr. DeWalt's lawyer had drafted a proposal for 3 hours unsupervised, which I was willing to agree to. I just wanted to make sure for Harmony's emotional well-being and transition out of Family and Child Protective Services from doing the visits there into his home. I had just requested that I could stick around for a few minutes and then kind of just let myself out while they had finished their 3 hours. And Mr. DeWalt was not willing to agree to that at all. And then I was a little confused with what I got in the email with the mail from 9 to 5. If possible, I'd like to request starting off with 3 hours, which is what his lawyer had proposed, unsupervised, along with, I have spoken with the Battle Creek Police Department a few times. However, I was not able to get the police report. I can do that. If I can...
I'm gonna object to this. This is simply slander. And if there were any legitimate concerns, Ms. Perkins could have submitted them to the court in writing. And this is just subterfuge, and that's what happened in June was subterfuge. So we are forced to present this matter to a neutral third party, being Your Honor.
Okay, well, let me listen to see what she has to say. Go ahead, ma'am.
Thank you, Your Honor. And I just want to finish by saying I have spoken with them, and they are familiar with with some drug activity. I was in Derek DeWalt's home a few months ago to discuss parenting time. And that's when I had found that there are other residents in his home that do rent from there. So just for the safety and concern of Harmony here, I would like to request just a home inspection before Harmony is placed there with other residents that I do not know. Am not familiar with any of their background. I understand if that can't be done. However, I just like to request that. But most importantly, I would like to start off with 3 hours, if possible, before we move from 9 to 5, given his lawyer had drafted that.
Okay. Okay, well, apparently the defendant has been as agreeable with 3 hours of unsupervised. The plaintiff is asking for more. What I'm going to do is obviously transition this in. What I'm going to do is where we will allow the parenting time to occur again twice. Apparently they've asked for twice a week for that time. I'm going to do it twice a week for 3 months for a period of 5 hours from noon to 5, 12 o'clock noon to 5 o'clock p.m. And then what we will do is extend the matter out at that point. We will have it from for a period of 3 months. We will do it alternating weekends, but we'll do it from Saturday morning at 9 o'clock a.m. to Sunday at 5 o'clock p.m. plus the standard midweek. And we will do that for another 3 months. And then we will go to standard parenting time unless there is a valid objection or, again, some basis for not extending that. So it would go for those 6 months before it goes to the standard parenting time. At the time it goes to standard, then the court would be willing to, again, at that point, and also include the standard holidays and half the Christmas, et cetera. At that particular point, the court will allow the plaintiff to have as one of his days the July 27th, the child's birthday, for up to the 5 hours. And you can include all of that in an order, Ms. McKenzie, and submit under 7-day notice of entry. I'm not going to award any fees at this time.
Your Honor, with regard to the days for the parenting time to begin the first set of parameters the court provided this morning, 3 months, 5 hours, noon to 5 p.m. Can we do that Saturdays and Wednesdays? Because I'm not anticipating an agreement, Your Honor.
We can put it in Saturday and Wednesday unless the parties otherwise agree.
Your Honor, can I just say something real quick?
Yes.
My daughter does return to school next month, so during the week is not going to work. She goes to school Monday through Friday from 8 to 3.
Okay.
So I could do Saturdays and Sundays.
Well, Ms. McKenzie, why don't we do Saturdays and Sundays and do those days, and then that way we don't have any conflict with school.
That's acceptable. Thank you, Your Honor.
Okay. Thank you.
Thank you, Your Honor.
Court will end this matter at 9:06 a.m. The defendant, this is before the court on Ms. Savage's motion to withdraw in this matter. Ms. Savage.
Thank you, Your Honor. My reasons for seeking to withdraw in this case are fully set forth in my motion, Your Honor, and unless you'd like me to reiterate them here, I'll rest on the text of the motion and request permission to withdraw as counsel for the defendant.
Nope, I don't need you to go over that. Who else do we have here?
We have plaintiff. I did just have someone join. I'm not sure. Let me bring them in to make sure it's not.
Okay. Defendant, we just had Ms. Savage state again the motion, saying that in fact the reasons set forth in the motion are a reason for withdrawing. Do you have any response?
I missed the reasons that she mentioned for response, or
They're in the motion. They're in the motion, and you weren't here at 9 o'clock when the motion was to start, so you missed that. So you have to read your motion, I guess.
I'm so sorry, sir.
Okay. Do you have any response?
Absolutely. Sure.
Okay. Am I supposed to guess at it, or are you going to tell me?
Oh, no, I can absolutely tell you, sir. Sorry.
Okay.
Again, I don't know exactly what she said, but my response is, if the attorney wants to not continue to represent me, that's fine. Communication absolutely has been a lack of communication. We just haven't been, I don't know why we can't coordinate or get on the same page. So it's been not it hasn't been a great experience with Ms. Savage, and not for the lack of trying during this divorce hearing or experience. But like I said, if she wants to leave, she's more than welcome. We just need to finish this divorce and get it done. So
Okay. Thank you. Plaintiff, do you have any response?
This time.
Excuse me, I didn't hear that.
Not at this time.
Okay, thank you. Well, the court doesn't seem to be any opposition. The court will grant the motion to withdraw. Ms. Savage, you can submit that order under 7-day, and we'll get the matter completed. The court will end this matter at 9:10 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
Thank you.
Judge.
Yes.
So what happens to our divorce during this? I don't understand.
It'll proceed the same way it would proceed in any event. You just don't have an attorney at that point.
But everything is signed. Am I correct? Are we good to?
I don't know. We'll have to look at it. That's not before me today. The only thing that was before the court was the motion. So that's the only thing I'm addressing today. If again, that's going to be up to the plaintiff now to schedule the final hearing in if everything's signed.
Okay. Do I need to get another attorney
That
at this point?
I can't tell you one way or the other. That's up to you as to what you want to do.
This is okay. Thank you, sir. Again, my attorney, no communication. I don't know what to do. I'm
Okay.
left out here in the wind by myself.
Okay, thank you. Our hearing's over, so you're excused. Mr. Vanderhorst on behalf of plaintiff,
Thank you.
Ms.
Have a great
Podolsky on behalf of defendant. This matter is before the court on the plaintiff's motion for temporary custody support parenting time. Mr. Vanderhorst.
Thank you, Your Honor. Parties have one minor child in common, Oakley, age 1. Defendant has not allowed the plaintiff any parenting time since May 19 of 2023. The parties met because the defendant was the plaintiff's therapist through KPEP. The plaintiff was released from prison and the defendant was plaintiff's therapist for about a period of 2.5 months. Plaintiff believes that the defendant was ultimately fired from KPEP because of her relationship with the plaintiff. The defendant was fully aware of any criminal history the plaintiff has because she was his therapist through parole and would have full access to his criminal history. Due to the fact that the plaintiff was on parole after the child was born, there was a blanket condition, part of his parole, that he could have no contact with any minor children. This is only a brief period of time he was not allowed to be around the party's minor child, which only lasted about 3 weeks, not 2 months, as alleged in defendant's answer. Plaintiff is no longer on parole or has any criminal pending charges. Since the party separation, the defendant has made herself unavailable to the plaintiff. She has blocked his phone number, blocked him on social media, and has also not responded to his emails. The plaintiff has reached out to defendant's friends and family members to see the child, but defendant would still refuse him his time. The plaintiff has and is willing to support the minor child, but has been unable to do so because defendant has blocked his phone number. Plaintiff has continuously asked for time with the minor child, and defendant has denied him any time. She has only offered him 15 minutes at the plaintiff's work. In this last visit that occurred this last July 2nd, I believe, this was a Sunday. This is the last time the defendant actually had any sort of parenting time with the minor child. The defendant messaged the plaintiff that the plaintiff could come over to the defendant's brother's home. This was at 5:30 at night. Plaintiff immediately left his residence. He lives near Grand Rapids, Michigan, hour and 15 minutes away. Came down, spent some time with the minor child, but then had to leave because he had to get ready for work the next morning. He works at 6:30 in the morning at ABC Supply on Battle Creek. Parties were living approximately an hour and 15 minutes away. As of yesterday, the plaintiff has moved to Battle Creek and is currently renting a bedroom in a friend's home where he has his own bedroom and sufficient space for the minor child. When the parties separated, the parties agreed that the plaintiff would take the crib. The defendant has 2 other cribs for the minor child. The utilities at the home were shut off due to defendant asking plaintiff to do so. The plaintiff has concerns about the defendant's substance abuse. He has firsthand knowledge of her consuming marijuana edibles, drinking, taking prescription medication, whether prescribed or unprescribed. Plaintiff believes that due to her ingesting these substances may impair the defendant's ability to watch the child or wake up when she is crying. Plaintiff is also concerned that the defendant is not physically present with the child. She works until approximately 9 p.m. every night. She lives in Battle Creek but works in Hastings. Plaintiff is employed at ABC Supply, like I already stated, at Battle Creek, works approximately 6:30 a.m. to 5 p.m. Monday through Friday. Plaintiff does have childcare available for the minor child. The plaintiff has not been denying paternity. In fact, it has been defendant who is telling friends and family that she cheated on plaintiff and the child's not his. The plaintiff is concerned with the defendant's substance use and the fact that the defendant is often gone from the residence during the week and doesn't arrive home from work until late in the evenings. Therefore, the plaintiff would like a parenting time schedule consisting of him having the minor child Monday through Friday, with defendant having parenting time every weekend, Friday through Sunday, with plaintiff being awarded sole physical and legal custody. Thank you, Your Honor.
Okay, thank you. Ms. Podolsky.
Thank you, Your Honor. My client denies all of these allegations as they are grossly untrue. This minor child was born approximately 1 year ago. For the 2 months after the minor child's birth, the plaintiff father was not to have any contact with the minor child due to his parole for his CSC conviction, for which he had been imprisoned for almost 10 years. After meeting with his parole officer, documentation was signed that allowed the plaintiff to have contact with the minor child only if it were supervised by the defendant mother. He was released from his parole at the end of March 2023. at which time this situation took a significant turn. These parties had been involved in a romantic relationship, but upon his release from his parole, the plaintiff became a different person. He moved out of the party's home in the early month of May 2023. He drained their joint bank accounts. He took anything of value from the home and took all the vehicles. He alleges that my client has blocked his number, but that's hard to do when he shut off her phone, canceled her phone number, and would not release it back to her to get a new phone. He alleges that she's denied parenting time. This is blatantly false. She has offered parenting time. She's offered for it to be supervised. She's offered it at places of employment, at her home, at the home of her parents, and with other family members present. It is the plaintiff who has denied all of this parenting time that has been offered to him. When he does contact her or make attempts to contact her through social media, email, and other means, he is denying his paternity. He is doing that to other people in their lives, friends, family members. And he is talking about any issue that is not related to the minor child. He has not inquired about the minor child's well-being. He is not providing financially for her, and he has certainly not been asking to see her. It has been the defendant who has been offering this parenting time. The allegations regarding her substance use, again, are grossly false. My client is an MSW. She is a therapist. She worked for our own Calhoun County DHHS for 4 years as a CPS investigator and has testified before this court on multiple occasions. In total, she had worked for the DHHS in various counties for 10 years. She served on drug court in Kalamazoo County. These allegations that she is using and abusing substances are blatantly false. This plaintiff, this father, has no relationship with the minor child. His parenting time has always been supervised. The defendant mother has been the primary caretaker of this minor child since birth. When he was with the minor child, the father's form of parenting was to prop her up on a couch with a bottle so he could play video games. It is the plaintiff father who is going to the local dispensaries, purchasing edibles and other items for consumption, while my client has been working full-time to support this family. She has a strong support system in her parents and siblings who are able to assist with childcare. Because of the plaintiff father's very serious criminal history, which includes criminal sexual conduct, we do not believe it is appropriate for him to have unsupervised visitation with the minor child. We're asking the court to award the sole legal and physical custody of the minor child to the defendant mother with supervised parenting time to the father. My client does have family who is willing to assist in providing that supervision. Thank you.
Okay, thank you. Mr. Vanderhorst, any response?
Briefly, Your Honor, regarding the edibles, my client does not consume marijuana. He has a CDL license and he's also randomly drug tested at work. So that's false. He did purchase those for the defendant who was using those. Also, when the parties were residing together, when the defendant would go off and work, the plaintiff would be left at home to care for the child. So he had sufficient unsupervised time with the minor child. He has been reaching out to friends and family. He's been trying to make every effort to contact it, and he's been simply denied his parenting time. Any criminal charges are in the past, and the defendant was well aware of them because she was his therapist through KPEP. So she had undisclosed information to his criminal history. So, and she had a relationship with him. So we are asking for parenting time to the plaintiff, unsupervised Monday through Friday, Your Honor. Thank you.
Okay, thank you. Well, what the court's going to do in this matter, this is temporarily the court is going to grant to the defendant mother custody in this particular matter. That would be legal and physical custody. Court will order that the plaintiff would pay support consistent with the guidelines and the support formula. The court would grant the plaintiff supervised parenting time for 1 day a week up to 3 hours. If the parties cannot agree, then it would be a Saturday from noon to 3. The court would, in fact, allow the defendant to provide 3 names that could supervise. She can do that within 7 days. The defendant then has 7 days thereafter to pick a supervisor. And once that supervisor is picked, they can arrange the parenting time. And that will be the order of the court at this point, and then it will continue. Okay. Anything else?
Nothing. Thank you.
No, Your Honor. Thank you.
Mr. Vanderhorst, you can prepare that order. Submit under SEC on behalf of plaintiff, Mr. Todd on behalf of defendant. The matter is before the court on 2 motions, the defendant's motion for contempt and the plaintiff's petition to set aside order after hearing of April 26, 2023. Let me ask Mr. Todd, has the parenting time started at all?
It has not, Your Honor.
Okay. Well, all the other matters can be addressed in this case, and it sounds like we'll probably have to have a hearing on this, but the court does want to get the parenting time started. Mr. Stupak, why hasn't the parenting time been started?
Well, as we had set forth in our petition, the defendant has not seen the child for several years. He lives in the state of Florida. We don't know where he is currently residing. He's had several different addresses in the state of Florida. The child is 5 years old, has been attending summer school, and as I say, he's not seen the child for several years. So I think it's totally unfair to the child to be expected to go to the state of Florida, as defendant suggests. And I think there's going to have to be some kind of implementation done to establish the relationship between the father and the daughter. And that's only the tip of the iceberg.
Okay. Mr. Todd, what's your response?
Your Honor, Mr. Buzzo has been trying to effectuate his parenting time, and there is no motion in front of us to modify parenting time. There's no motion that's been filed to modify custody. So at this point, the order is the order. Additionally, the plaintiff's answer at best is strange. We don't know how she ever found out about this motion. And it alleges that she found out about the motion actually April 17th, which does not explain why she didn't attend the subsequent hearing in May, and also does not explain why she didn't call my office until June 6th to state her address. We believe this is kind of just a continuation of her trying to perpetuate my client from not having any parenting time. So we do believe parenting time is appropriate. It's not my client's fault that he hasn't been able to get a hold of the child and he hasn't been able to exercise his parenting time. And it's certainly not my client's fault that Ms. Hayek didn't ever provide an updated address with friend of the court pursuant to the court rule, which she should have.
Okay. Mr. Todd, is your client able to come up and visit the child in Michigan this particular month?
Yes, Ron, I believe he's willing and able. I think the key is making sure we have a pickup and drop off point because he does not have contact information for the plaintiff at this point. And so I believe if the court would set a pickup location, then he can certainly facilitate that. And then if the court wants to set that duration, that would be appropriate.
Okay. Can he visit on July 15th and July 29th?
I do have a couple of people. I'm not sure. Maybe he's like lost service. Let me try to bring these.
Okay, we're trying to bring in some other individuals. He might be on one of these other.
Wondering if he got like disconnected, but he's
Well,
still
for
on.
clarification, Your Honor, do you mean July 15th to July 29th or July 15th and July 29th?
July 15th and the 29th.
That I don't know. I apologize. I would need to check with him.
Yeah. Let's do it this way then. What the court's going to do is allow the defendant to have parenting time on 2 of the Saturdays left in July, the July 15th, 22nd, or the 29th, as he's able to. And Mr. Todd will have to give Mr. Stupak notice as to what those 2 Saturdays he's going to take. The court will set those up where he'll take the child from 12 o'clock noon to 6 o'clock p.m. on those 2 days. The exchange will occur at the Battle Creek City Police Department on those particular days. And then thereafter, the court will allow him on the 29th. So I assume he'll want to visit on the 29th. The court will allow him at that point to take the child with him to have the child in Florida for the month of August. to return the child 1 week before school starts in August. So I don't know when school starts, so you'll have to figure that out between the attorneys. But at this point, you'll have either the 15th or the 22nd, and then he'll take the child the 29th at 12 o'clock noon, and then have the child through August, when he'll return the child, whatever that date is. That's we'll have him return the child on this Saturday. Let's do it the Saturday before school starts. I don't know when school starts, and we'll have the return at 12 o'clock noon as well at the Battle Creek City Police Department. The other matters will all be set for evidentiary hearing.
Absolutely. Thank you, Your Honor.
Mr.
Your Honor.
Todd, yes, go ahead.
Excuse me, I anticipate, and the council is right, that there is not a motion to modify the custody support and parenting time. But I anticipate filing such a motion prior to any type of visitation. I recognize that you've indicated 2 Saturdays in July. I would hope to think that I'd be able to at least file something in the month of July that would ask that the court modify the existing order.
You can file anything you want. We'll have a hearing on that. I'm not changing this order on an interim basis. This order will continue until we have an evidentiary hearing on that particular motion.
Okay, very good. Thank you, Your Honor.
Okay, thank you. Mr. Todd, you can submit under 7 days. Ms. Reed, on behalf of the plaintiff, defendant is unrepresented. Mr. Morris, is it your intent to get representation, or are you going to represent yourself?
I'm going to represent myself.
Okay. This matter is before the court on the plaintiff's motion for temporary custody, parenting time, and support. I do note in reviewing the motion, I'll ask, has the child been, well, where's the child? Has the child been returned to the plaintiff or not, Ms. Reed?
The child was returned to the plaintiff. The child was withheld from May 29th until June 1st.
Okay. Go ahead, Ms. Reed.
Your Honor, we're requesting that my client be awarded temporary sole legal and primary physical of the party's minor child, Milani, who is age 3. Milani's been primarily living with my client her entire life, with the defendant exercising very sporadic parenting time. It might be from 1 day per month to maybe a weekend or every other weekend. He's kind of all over the place. He did withhold the child May 29th to June 1st. He was sending death threats as well as threats of violence to my client if she was going to show up to his house to retrieve the child. He would beat her, or his girlfriend would beat her. Upon returning of the child on June 1st, he went almost the entire month of June without exercising parenting time or really communicating with my client. He did have some parenting time in July, primarily this last weekend. He had Milani, and then yesterday Milani was returned to my client with a horrifying sunburn, and my client took the child to the emergency room when she started vomiting, and she was treated there late last night. When my client called Mr. Morris to advise him of the situation, he hung up on her. So again, we're asking for sole legal custody, primary physical custody to my client, a reasonable parenting time schedule for the defendant once he completes anger management counseling, some parenting time classes, child support under the formula, and we're requesting that he not exercise week on, week off parenting time during the summer, as he's never had the child longer than a couple of days.
Okay, thank you. Mr. Morris, what's your response?
That is not true. I get my daughter almost every weekend. And in June, I did try to get my daughter on Father's Day. She would not let me get her. My birthday was the following weekend. I went on vacation. And more and less, I have had my daughter almost every weekend.
Okay. What do you say to that, Ms. Reed, that he's saying he's had every weekend?
That is not correct, Your Honor. It might be a day on a weekend. He might have every other weekend, but it has not been every weekend.
Well, what we'll do is the court is going to grant to the plaintiff the temporary legal and physical custody of the minor child. I will grant child support consistent with the child support formula and the guidelines, effective the date of the notice of the motion. The court will order that the parties would communicate through our family wizard. I'll let both of the parties know, as you communicate through our family wizard, that record is kept. So the court will have that for any subsequent proceedings. So if, in fact, it turns out that is anything untoward stated or done during those particular communications, recognize the court's going to have a record of that. So if you come in a few months and say, well, he hasn't done this or she hasn't done that, the court's going to have a record of that. So just so you're aware. The court is going to, at this point, until we have a hearing, the court is going to grant to the defendant parenting time on alternating weekends and a midweek, Wednesday, if the parties cannot agree to another day, for up to 4 hours. And the court will alternate holidays at this point. That will be the order as it relates to parenting time. Ms. Reed, I'll ask that you would prepare that order, submit under 7-day notice of entry, and we will conclude this matter at 10:55 a.m. McNiff, on behalf of the plaintiff, have a good day. This matter is before the court on the plaintiff's motion for temporary custody, parenting time, and support. Mr. Schultz, I'll ask, you're not represented. Do you intend to get representation or intend to represent yourself?
As of right now, I'll be representing myself until I can afford a lawyer.
Okay, that's fine. Ms. McNiff, you can proceed.
Your Honor, we are looking today for both sole legal and sole physical custody on a temporary basis. This child has significant health concerns. Mom's unable to work because she has to attend to this child. The child has to attend therapy at least twice a week and has significant medical appointments as well. Mr. Schultz has not been involved in a significant way with the child's medical care or the medical decisions, which is why mom is seeking sole legal custody. The parties have had significant disagreements regarding the child's therapy, even though the child is under the care of a neurologist and a primary care physician who both recommend the therapy. And I detailed why the child has the significant health problems in our motion. We're also asking that Mr. Schultz be considered to be able to make the sum of $21.50 per hour. He was making that amount at Clemens. We understand that he voluntarily left that position, that he was not let go from that position. We also have concerns about Mr. Schultz's use of alcohol, and we don't believe that it's appropriate for him to be using alcohol in the event that he has parenting time with a child. At this point, we think the safest provision for parenting time would be to have it supervised at Family and Children's Services. And then in the event that Mr. Schultz can show more of an interest in the child's medical care and show an interest in learning how to take care of this child, we could explore expanding that parenting time at that point.
Okay, thank you. Mr. Schultz, what's your response?
To that, yes, I have been there and done a lot with my son and know of his medical conditions. And I was not able to attend a lot of the therapies and everything due to I was the only one in the household working to support us. And yes, I would like to be able to see my son. It's been going on 2 months, whether it be weekends, supervised visits, whatever I can get for right now, just as long as that I can see him. And I was drinking at the time that we split up, and I am no longer drinking and looking for a job. And I'm looking in the area locally because I have no means of getting anywhere out of town in Albion now. And I was not let go from Clemens, but I had no way when I was over an hour away with no vehicle. So that's why I no longer work there, but I am searching for work in Albion right now and have a couple job interviews set up this week. They may not be for the $21.50 an hour, but it'll be something.
Okay, how much will those jobs be paying? Do you know?
One's $15 an hour, and the other one I have an interview for tomorrow. They did not let me know what the starting rate pay is.
Okay. Well, what the court's going to do on a temporary basis, court will grant to the plaintiff temporary legal and physical custody in this matter. I'll get support consistent with the child support formula guidelines. The court will impute $15 per hour to the defendant in this matter, and that will be support will be subject will take effect as of the date of notice of the motion in this particular matter. The court will grant to the defendant supervised parenting time. That will be in alternating weekends on both Saturday and Sunday for up to 4 hours. If the parties cannot come to an agreement, then it'll be from noon to 4:00 p.m. That the plaintiff will submit 3 names to the defendant of supervisors, and which she'll do that within 7 days, and then he'll have 7 days thereafter to pick a supervisor. And after the supervisor is picked, then by the defendant, then we will commence the parenting time the Saturday after that. So any questions, Ms. McNiff?
No, I've got it, Your Honor. Thank you.
Okay. Any questions, Mr. Schultz?
No, there's not.
Okay. Mr. Schultz, Ms. McNiff will be preparing that order. She'll submit it under a 7-day notice of entry.
Your Honor,
You have-
can I add a provision? I'm sorry to interrupt. Can I add a provision that there's to be no drinking during the parenting time?
Well, I'm not going to do that at this point. He's stating he is not drinking. If in fact it turns out that he does during the supervised, you can always file a motion at that point to prohibit the drinking.
Very well, Your Honor.
That'll not be a problem.
Okay, thank you. Hopefully not. That'll end the matter at 10:02 a.m. Plaintiff, Ms. Podolsky, on behalf of defendant. This matter is before the court on the defendant's motion for post-judgment relief. Ms. Podolsky.
Thank you, Your Honor. First, I would like to state for the record, there have been a few agreements in this matter. First would be the exchange location for parenting time. The parties have agreed to exchange at the fire station located at the corner of Morgan Road. I believe it's North Ave. Parties have agreed to do all child exchanges there that do not occur at the minor child school itself. The parties have agreed to utilize our family wizard. And then lastly, we were here 2 weeks ago where the court issued a ruling on vacation time for this summer. The parties have further agreed to follow what was proposed in that section of our motion in notifying each other what week they would like for future summer vacations, and that they agree not to take vacation time over the others' holidays, such as a Father's Day, Mother's Day, or 4th of July. So those are the agreements that have been reached prior to today's motion hearing.
Okay. Ms. McKenzie, is that accurate?
It is, Your Honor.
Okay, thank you. Ms. Podolsky, you can proceed with your motion.
Thank you, Your Honor. These parties were divorced in December of 2022. They share joint legal and physical custody of their daughter, who just turned 6 years old last month. Since prior to the entry of the judgment of divorce, the parties have been exercising a parenting time arrangement that differs from what's in the judgment. The judgment provides for just a standard week on, week off. However, these parties are exercising a schedule wherein the plaintiff has the minor child with him every Sunday through Wednesday. And then from Wednesday after school until Saturday, the minor child is with the defendant. And the parties alternate that Saturday overnight. This is still a 50-50 schedule, but this is the schedule they've been practicing since prior to the entry of the judgment. They have memorialized this in a Google Calendar that runs into perpetuity that they share with each other. They also have other important matters on that calendar, such as medical appointments, school activities, etc. And that's what they use to handle their child-related matters. We are asking this court to memorialize this schedule in an amended or an order amending the judgment of divorce, because this is what they have been practicing. This is what the minor child is used to. These parties were doing this in order so that the minor child isn't going too long without seeing either parent. Next, Your Honor, there is a Scrivener's error in the judgment of divorce as it relates to the holiday schedule. It addresses that defendant father shall have certain holidays in even years and other holidays in odd years. The defendant in this matter, however, is the mother. We're asking for that Scrivener's error to be corrected to read plaintiff father. Further, the judgment of divorce does address the minor child's birthday. It says the party should split that day. Her birthday falls on a day that would be outside of the school calendar. There is not a proposal in the judgment as to how they should split that day, and that has become an issue. So we are proposing that in odd number years, the defendant would have the minor child with her from 9 a.m. till 2 p.m. Plaintiff would have the minor child with him from 2 p.m. until 7 p.m. And then they would flip-flop that in even numbered years. Further, these parties had been allowing phone calls and or FaceTime or Zoom with the minor child during parenting time. The plaintiff unilaterally stopped those phone calls. My client does not believe this is burdensome for either party. She believes it's important for each party to be able to talk to the minor child when she is in the other party's care. We are not asking for unlimited phone calls all day, every day during parenting time. We are asking for 2 10-minute phone calls when the minor child is in the other parent's care. Again, we do not believe this is burdensome on either party. We requested that call occur at 9 p.m. We are willing to move that to 8 p.m. to accommodate bedtime routines. There is a section in our motion related to summer school and tutoring. This motion was filed prior to the beginning of a summer reading program that the minor child was enrolled in. This was something the parties agreed to well before the start of that program. And then my client was unable to reach the plaintiff prior to the start of that program to assure herself that the minor child was in fact still attending. This has not become an issue. However, we don't want this to be an issue in the future. This could have easily been addressed if the parties could just communicate. So we are happy that there's an agreement as to our family wizard, but we are asking that for any future summer school and or tutoring that the parties will ensure that the minor child does get there during that scheduled time and during their scheduled parenting time. We had a lot of issues in this motion, Your Honor. Thankfully, we were able to address some of them prior to today's motion hearing, but this entire motion could have been avoided if there could be civil and respectful communication between the parties. Unfortunately, it is the plaintiff father who has been dictating how and when things should occur. Some of this is related to the Scrivener's error regarding the holiday parenting time, but others, it's just his way of controlling the situation. We believe that it would be appropriate for these parties to participate in co-parenting counseling, to be able to work together for the best interests of this child, to be able to communicate with each other civilly and respectfully, because they are going to co-parent this child for the rest of their lives. And as I stated, she's only 6 years old now. So we are asking that the court enter an order directing these parties to attend co-parenting counseling. Thank you.
Okay, thank you. Ms. McKenzie, obviously, as Ms. Podolsky states, there's a typo that identifies father as the defendant. Why can't that be corrected?
That isn't an issue in terms of my typographical error, Your Honor, but what would be appropriate, my client, I think, messed up because of my typographical error, and he has taken the opposite holidays, but those coincide with the holidays that he has with his 10-year-old son, Liam. And so by continuing what has gone on this year, then he would, Kennedy, the child we're concerned with today, Kennedy would be able to get a chance to spend time with her brother. So although I did have a typographical error, which did cause a problem, I suggest that I correct that to say that in the year 2023, Mr. Howe gets Easter, 4th of July, Thanksgiving, Christmas Day, and then Ms. Howe has Memorial Day, Labor Day, Christmas Eve Day this year. So just flip-flop them for the reason that the way the parties have been doing it for 2023 coincides with Kennedy's ability to visit with her 10-year-old brother.
Okay. Ms. Podolsky, understand wanting to correct the typo, but doesn't it make sense that we might change that this year to accommodate the children being together and then change it in 2024?
Your Honor, my client has been relying on the judgment of what holidays she was awarded. Ms. McKenzie has stated that her client has taken the opposite holidays, and that's absolutely what he did. He took them, he dictated what holidays my client would have. She was relying on that judgment of divorce, and she believed that she was having the upcoming holidays of Thanksgiving and Christmas and has made her own plans and arrangement with family. So we're asking the court to simply correct that to read plaintiff father.
Judge, and for a point of clarification, I'm looking for the schedule to continue as it is, where the parties flip-flop a schedule. So next year, I'm not looking just for 2023, but I was just mentioning to the court what holidays my client has taken and would be taking based on the parties' practice in 2023. But going forward, because we've got a 10-year-old, my client has a 10-year-old son. And so, of course, he has the same alternating holiday schedule with Liam as he does, or as he now, by mistake has taken with Kennedy. So I just want to clean that up so that the children are able to be together. And
I understand that, and apparently defendant's not willing to do that. And again, the court at this point is going to correct the typo to say that it's again, that it's plaintiff father. At this point, I'm not going to change any dates or change any times because the defendant's not agreeable. And that's unfortunate, but obviously it, again, reflects why we're here today and why we can't get an agreement. Go ahead, Ms. McKenzie.
So going forward, Your Honor, I correct that, and then the holiday schedule and judgment of divorce prevails after I correct my typographical error. Is that what
that's correct? And he'll have to try to change it as to the other child and work it out that way.
Correct. All right. Thank you, Your Honor. With regard to co-parenting counseling, yes, we do agree to 4 sessions of co-parenting counseling. I recently learned that Ms. Howe, defendant Howe, is in personal counseling. And so I am not requesting that she be required to start counseling, but I do request that she be ordered to continue her counseling, her personal counseling. But I am in agreement with 4 sessions of co-parenting counseling, and with the parties equally sharing any uninsured expenses for joint sessions.
Okay. Ms. Podolsky, you were the one that suggested the co-parenting, so I assume you won't dispute that.
I don't dispute the co-parenting counseling. I do dispute the 4 sessions. I would think in theory, the counselor is probably going to want to have an individual session with each party to understand concerns, any history here, what they're trying to get from this counseling. But from there, it should be at the discretion of the co-parenting counselor as to how long the counseling sessions should last and when they should end, and not be stuck with this 4 session and trying to cram in however much work needs to be done in those 4 sessions. So we'd ask that be left to the discretion of the counselor.
Court would allow that to proceed in the discretion of the counselor. If again, it gets to be extensive or onerous, Ms. McKenzie, you can always file a motion to terminate that.
With regard to the parenting time, I'm asking the court to either order Monday to Monday, being a week on, week off, with midweek parenting time per the judgment divorce, or simply to order that what was agreed to in the judgment of divorce, which was Friday 6 p.m. to Friday 6 p.m. with midweek parenting time, that be reinstated and in fact ordered again by the court. This allows the party's daughter to see each parent in the middle of the week, touch base with mom or dad from after the work hours until 8 p.m. So I think that would be in the child's best interest, and that was already determined. That was already accepted by Ms. Howe. So the unusual schedule is not necessary. We do suggest that Monday to Monday is appropriate and a better deal, just in terms of transportation for the child and transportation needs for the parents. Ms. Howe does not drive and will not drive. She will not have a license due to some medical reasons, and Monday to Monday would enable the parties to take advantage of school bus transportation during the school year. So I'm asking the court either to change the 1 week on, week off to Monday, or to just simply reinstate what the parties agreed to in their judgment divorce, Friday 6 p.m. to Friday 6 p.m. Do you want me to go forward, Your Honor?
Yes.
All right. With regard to the phone calls, the 2 10-minute phone calls, I don't think those are going to be necessary when if the court reinstates the week on, week off with 4 hours midweek parenting time or parenting time from after this workday until 8 p.m. That will not be an issue. Should the court choose not to do that, then we ask that the court limit the phone calls to 1 phone call during the period that when the parent does not have Kennedy with them, 1 5-minute phone call. And the reason is, Judge, in a single day, my client got 43 phone calls from the mother on a single day. That was March 22nd of this year. And during the month of March, he received 95 phone calls from the mother. And that is the reason that the phone calls just simply needed to be discontinued. The phone calls were not significant. The child was not having a medical crisis. Neither parent was having a medical crisis. They were simply harassment calls. And quite honestly, Your Honor, I'm 5 minutes. If these phone calls continue, or if it gets the phone call privilege gets abused again, I'm 5 minutes from telling my client to get himself a personal protection order. I don't want to do that. He doesn't want to do that because it's a bad idea for parents to have PPOs against the other parent, and it is not beneficial, typically not beneficial for the child. So I think 1 phone call, 5 minutes, or FaceTime, whichever works for the parties. That's enough for the parent to touch base. And I'd like it to be before 8 p.m., anytime before 8 p.m., because that's the time when at my client's home, things start winding down to get Kennedy ready for bed. So sometime before 8 p.m., a single call would be appropriate if the court chooses to address that at all. Let me see here. I don't have a problem with the proposed birthday splitting. If the defendant mother insists on splitting that, that's fine. Her schedule would be acceptable. And our family wizard, we're fine with that. I believe that covers all of the matters, but we do ask for attorney fees based on the tenor of this motion. And I'd ask for $550 of attorney fees, Your Honor.
Okay. Court will again have the birthday parenting time as suggested by Ms. Podolsky and as Ms. McKenzie has agreed to in this particular matter. The court will, if the parties, again, if they can't agree, the court will go back to the judgment. So I'm not going to change the parenting time. If they can't agree, then they will, I guess, have to labor under what they agreed to in the judgment of divorce, which is unfortunate, but that's the way it is if we can't come to an agreement. The court will allow 1 phone or virtual or FaceTime phone call at 8:00 p.m. for up to 15 minutes while the child is with the other parent during that week. And the parent can notify each other when they do the exchange when that's going to occur, and whatever the date is for that. I think that takes care of all the issues. Is that correct, Ms. Podolsky?
Yes, I believe so. Thank you.
I'm not going to award any attorney fees in this matter.
Judge, I have a clarification regarding the court indicated birthday and parenting time will be per Ms. Podolsky's request. By parenting time, you're talking about the holiday time where I had the typographical error, correct?
No, I've already addressed that. I'm talking about the birthday. Ms. Podolsky suggested that
only the birthday,
her client from 9 to 2, and then 2 to 7 for your client, and then switch it the following year.
Okay, the court meant in that same sentence about 2 minutes ago, the court mentioned parenting time, birthday. So you mean birthday parenting time?
Birthday parenting time.
I had a comma there. I have another typographical error, Your Honor.
Oh, okay.
Thank you, Judge.
Anything else, Ms. Podolsky?
Nothing. Thank you.
Okay, thank you. I'll let Ms. Podolsky, I'll let you prepare it if you filed the motion, and that should you can submit under 7 days. Thank you all, and good morning to both of you. This matter is before the court on the defendant's motion to set aside the default in this particular matter. So, defendant, you can proceed.
Okay. I'm not really sure what to do here.
Well, it's your motion. Argue your motion.
Okay. I put in to set aside a default because I was, to be completely honest, a little ignorant in what I was signing as far as the agreements that we made. I submitted a copy of the things that I believe would help let me set aside the default. I think that the parenting agreement that was put into our divorce agreement is not what we really agreed upon. The inconsistencies in Justin's efforts in spending time with our children doesn't reflect in the agreement that was put into the divorce agreement. I was ignorant in signing things, and I would just like a little more time to sort of fix that situation so that it's not an issue in the future.
Okay. Mr. Jones, what's your response?
So the only thing that was signed was that she received the bundle of paperwork that I got from Michigan Legal Help. The default was after the amount of time that she was supposed to review those documents. And then it says here on number 3 that there was nothing to worry about the default. That was accordance to the dismissal for non-progress. She called me or texted me, one of the two, and I told her that was something that I can take care of. So I called the court, the judge's office, to figure out what I needed to do next. With the inconsistencies, the prior arrangement was I was paying for mostly everything at where she was staying and the kids, because I believe that was the right thing to do.
Okay, sure. I don't want to get into specifics because her motion is to set aside the default.
Gotcha.
So that's what we're addressing at this point. So are you opposing setting aside the default?
I am opposing.
Okay.
Yep.
Okay. Well, ma'am, the default was entered back on December 7, 2022. So you've had sufficient notice. I mean, now it's, you're talking, basically 7 months that the default's been in place. And obviously the case is 248 days old.
Yes, sir.
Why did you wait?
So I'm going to claim ignorance here. Until I went in and I was talking to the county clerk, I believe, I didn't even know what an answer was. When he originally, filed for divorce, I was pregnant at the time, and I just trusted the situation and that we would come to an agreement. If I could go back and redo it, I would read better. I'm sort of at the mercy of the situation right now.
Well, in this particular matter, the court finds that there is not a good cause to set aside the default. You've not alleged, either in your pleadings or today, you've not alleged good cause to set aside the default. The default, as I stated, has been in existence for 7 months. The case is 248 days old. And there's, again, the court does not find a basis to do that. So I'm going to deny the motion to set aside the default in this matter and leave it up to the plaintiff to proceed with the entry of the judgment. And that will be the order. Sir, what you're going to have to do is you're going to have to do an order denying her motion to set aside the default. And if you submit it within 7 days, then we can get it entered at that point. If you take longer than 7 days, then you're going to have to schedule it up for a hearing. Okay?
Understood.
Okay. Thank you. The court will end this matter at 10:33 a.m. You're free to go. Have a good day. Okay. Good afternoon to everyone. I will start with Ms. Abu Farah because you represent the plaintiff. This is the time and place set for the status conference. Ms. Abu Farah, bring me up to speed. What's happening in the case or not happening?
Yes, Your Honor, I will certainly do that. I contacted opposing counsel in respect to getting an appraisal on the marital home. We agreed on the appraiser that we would use. I contacted the appraiser. I got the amount of the appraisal cost. I then forwarded that information to Attorney Toth. Since then, I've contacted him on 3 other occasions, and I have not heard back from him since on whether or not his client is willing to pay half for the appraisal cost. My client was ready, willing, and ready to move forward with getting the appraisal done on the marital home. That is the only thing that's keeping us from settling this matter at this time, as well as I've mailed out our financial disclosures on June 29th of 2023. It's July 10th today. I have not received the defendant's financial disclosures, so that's also holding up the process.
Well, we'll find out from Mr. Toth. What's happening, Mr. Toth? And why are you not being cooperative with Ms. Abufar?
Your Honor, if we're on the record, I received today the financial documents from the plaintiff. My client today brought his in. I've just got to make sure everything's there, and they'll be emailed as soon as we verified we have everything that we need. The case is far more complicated than the getting an appraisal, Your Honor. My records show that the house was owned premaritally by my client and his brother as joint tenants with full rights of survivorship. I have a copy of the deed. The deed was recorded. I'm not aware as to whether or not there's a subsequent deed that's been issued in this case or recorded. I don't know. Maybe I saw nothing in plaintiff's counsel's documents as I just perused them that would show an alternative deed. Maybe she could answer now. Do you have a deed that differs from what I have?
Are you asking?
Do you have a deed?
I do not, but the house was refinanced in April of 2022 by Mason Morrill through Rocket Mortgage. And that was while we were married.
Okay, then as Mr. Toth states, it sounds like there is much more complex than would first meet the eye.
So regardless, Your Honor, I think whether or not all or a portion of the real estate is determined ultimately to be non-marital, I think it's relevant that its present value be established. I've talked with Mr. Morrill today, and he will agree to pay 50% of an appraisal. Again, I have a deed that was recorded back on October 24th of 2019, and it identifies that there was a conveyance from Travis Morrill to Travis Morrill and Mason Morrill as joint tenants with full rights of survivorship. So it's not only a complicated form of ownership in that the court's not authorized to divide this under usual circumstances, but furthermore, this conveyance was premarital. So there are complicating issues, Your Honor. I'm not trying to advocate what the outcome should be, simply that this is an issue we have to deal with. So for today's purpose, on the record, Mr. Morrill will pay 50% of the appraisal. We'll have the domestic relations verified financial information form emailed to counsel by the end of the week. Given the state of affairs, Your Honor, I think that probably the court should order facilitative mediation.
Okay. Ms. Abufar, what do you think as it relates to mediation? Does that sound appropriate?
At this time, it does sound appropriate, Your Honor. I was unaware of what Attorney Toth has stated on the record today. He has not communicated with me about any of these issues. Had I known, I would have taken a different step back on the appraisal issue, but it's kind of hard to know what's going on in the case if the other attorney's not communicating. So moving forward, we'd get the appraisal done. We'd have a facilitated mediation. We're not opposed to that. We just need to know what's going on moving forward.
Okay.
I'd really appreciate it.
Mr. Toth, who would you recommend as a mediator?
John Brundage, primary, and Kelly Podolsky as a secondary mediator.
Okay. Ms. Abufar, is that agreeable to have Mr. Brundage serve as a mediator and then Ms. Podolsky as an alternate?
Yes, we've used both of those services, both of those offices for mediation out in that area.
Okay.
And they both conduct them via Zoom as well.
Ms. Abufar, because you represent the plaintiff, I'll ask that you would prepare an order sending the matter to mediation with those individuals and having a separate mediation in September. You won't get into Mr. Brundage before September. because of his schedule, have it scheduled in September. And then if you would put in the order as well, that the court will schedule the matter back for a settlement conference on October 2nd at 1:30 p.m. Good afternoon. I'll start with you first, Mr. Hall, because you're the plaintiff. Tell me what is happening in the case at this point.
What's happening in the case is she took Delilah. I've been trying to get her back. And so far that's the only thing that's going on.
Okay. At this point, court notes we don't have mediation did not occur as the defendant failed to contact the mediator or to pay the mediation fee. So at this point, all we can do is set the matter for trial. I'll ask Mr. Hall, how long do you think we're going to need to try this matter?
I'm not understanding, sir.
Well, I'm asking the amount of time you believe it'll take to try the case. Are we talking a day, 2 days, more days? What?
Well, if we can get the mediation scheduled, we can have all this sorted out through a mediator. I mean, I don't know why we got to go to trial.
Well, you could, but the defendant did not contact the mediator, nor did she pay for the mediation fee. So the mediator is not going to mediate the case. I guess I'll ask you, Ms. Hall. Ms. Hall, was it your intent to mediate and there was some confusion or what?
I can't afford that at all. There's no way that I can afford.
Okay, then you'll end up going to trial then at this point.
That's fine with me. The only thing that we're fighting over at this point is our daughter.
Okay.
This really has nothing to do with anything else. Our property is already split and everything.
Okay. Well, what the court will do is the court will set the matter for a 1-day trial. And hopefully we can get the matter resolved at that time.
Sir, when is this going to happen? Because I'm going to have to take work off for that day.
Yeah, you will have to do that. I don't know. What I'll do is we'll try to get in touch with both of you and find out what works in your schedules. If we are not able to work it into your schedules, the court will just set a date and then you'll have to appear on that date, but we always try to work it out if we can. So hopefully we can, and then we can set it for trial. And, the trials, I will tell you, the trials will start promptly at 8:30 a.m. So be present for that. And then we will proceed, be ready with any witnesses that you have. There was a case scheduling order entered in this matter back on April 26, 2023. It set forth what is required for the trial to proceed as it relates to, again, your disclosure of exhibits, your disclosure of witnesses, et cetera. So make sure that you read over the case scheduling order, because if you have not properly filed the paperwork necessary, you may not be able to get witnesses in or exhibits. So I'll just draw that to your attention. Okay. Anything else, Mr. Hall?
So are we looking at a couple weeks out?
Probably a couple weeks. Yes.
Okay.
It might be longer. I don't know. It could be longer.
If we come to an agreement before then.
If you come to an agreement before then of course there's no need to go to trial, but that's up to you.
All right. I guess me and her can sit down and figure some stuff out, because I can't keep missing work, sir.
Okay. Well, then you'll have to try to do that. And I suggest you do it right away so that you can get it resolved. We will be in touch with you probably later today or tomorrow to try to schedule the trial.
All right.
Okay.
So if we do, one more question. So if we do solve and end this matter today, do we just call your office and say, hey, we reached an agreement? Or
yes, you have to call my office. Then what happens, you'll have to do the paperwork for putting together the judgment of divorce and the uniform child support order, et cetera. But you can get that off MichiganLegalHelp.org. So. Okay.
I already got the paperwork and everything. I've already filled all that out.
Okay.
So all we got to do is
Okay,
sit down and discuss what we need.
that's good.
So me and her
Okay.
will.
See if you can't do that, and hopefully you can, and we can get it resolved and then proceed. Okay? Anything that
thank
you have, Ms. Hall?
No, that's all. Thank you.
Okay, thank you both. Court will end this matter.